against this person, my lord. Only the allegation is that in the second paragraph of the FIR, my lord. During preliminary inquiry, it is found that four persons, namely Jiabur Rahman, son of so-and-so, Ruhul Amin, Shamim Akram, and Sadiqul Islam, all are village so-and-so, and others have been threatening people in the state area for money and other valuables. And this affair has been lost, my lord, by the SI of Hing police station. But my lord, there is no single FIR filed by any my lord local people with the allegation of demanding my lord money or extortion of anything, my lord. So, and my lord, regarding the my lord, the first paragraph, my lord, of the FIR, with due respect and humble submission, I have the honor to state that on dated 29/3/24 at about so and so, information has been received by OC Dhing police station regarding some people equipped with illegal arms are carrying out extortion activities at so and so. Accordingly, GD entry has been made by Dhing PS so and so, and the staff proceeded to the area to trace out the accused persons and take necessary legal action. At 2:50 p.m., based on the information, a raid had been planned to apprehend the accused persons in the said locality, but the persons had fired 4 rounds in the air in order to flee away and managed to escape before we could reach. Here, my lord, the main accused, he was arrested, my lord, and he was granted bail by your lordship, my lord, which is at page, my lord, 15, my lord. The Shamim Akram, he fired in the air, my lord, and he was arrested. The pistol was recovered from him, my lord, and he was granted bail by your lordship. So against me, my lord, only allegation that, my lord, that I have threatening people, demanding money, my lord. But there is no single FIR filed by any person of that locality, my lord. So
The other one was granted bail, I think.
My lord.
It was only after BA and after considering the bail petition only.
But what I am submitting,
or
my
your
lord.
petitioner earlier petition was rejected. So without prejudice of case that it should not be entertained at all. And that's true, there's no new ground at all.
My lord,
No
here,
new and urgent ground. What is your new
new,
Is there any?
my lord, this fact, my lord, if you lordship,
We call for the case there because
Earlier rejected.
my lord, in the earlier bail petition, my lord, this fact was, my lord, with my humble submission, my lord, this fact was not properly placed. That's why, my lord, lordship may kindly peruse the.
No, it's okay. We call for the case there.
And my lord, the regarding pistol, my lord, that has already been recovered. So, my lord,
You,
I,
in
my,
that area, you treat 2, 3, 4, 5% were free things.
but my lord,
Getting the people, even you didn't hesitate to fire arms.
my lord, that was fired. It was fired by the
When
accused.
will be called for?
After vacation, Lord.
After vacation. You want to fix any date or 1/3? 1/3. November 13th.
People in the last week of, my lord, October,
week
my
of
lord, October, my lord.
Last week of October.
Yes.
29 of October.
29th.
My lord, if you lordship protect me, I'll appear before the.
No, it's not a case of protection. Not at all.
Earlier
That's why
rejected.
earlier he was simply called.
Oh, bless.
Here also NCP is also there.
I think Lord.
Common is in this case we have received the scan copy of it. But is it the updated one or CD?
NCP.
Oh, it's an NCP. No? Scan copy of it. Not repeated the That he goes to that. Just it is present status report is also present status report also.
May I please, Your Lordship?
Here,
Lordship,
in earlier occasions, city was written and again called for. Or
Lordship, up to date, in my petition, it was written as up to date CD was called for along with the statement. I
Okay.
accused.
okay. So yes, on the last occasion, what happened? He submitted that the statement, the appearance statement was recorded.
Lordship, because how can he appear before the IO because he is behind the bar?
Yes, Lordship. I'm behind the bar, Lordship.
Oh, sorry, you are behind the bar.
Yes,
No.
Lordship.
But his statement was, I think, not available.
Yes, Lordship. On the earlier date, Lordship, my re-forwarding report and my statement was not there in the case diary.
Yes.
So
Ah.
it was
Yes,
a
what is the position now?
Now also it is
Now,
not.
because last entry of this CD is Lordship of 17/5. 17/5/2024.
So I inquired the matter then,
Date.
because it was the order that
Yes, sir.
he is in custody. So his statement should be there, and 40, 40 whatever it was.
Because the other case statement is there, but he is particular, he is not there. So I will
How long he was in custody?
today,
Lordship, he
as
was
on date 46. Yes, Lordship.
arrested on 1908, Lordship, date of forwarding.
Date of forwarding was 1908.
Lordship, I fix it on the vacation court
Vacation court
on
not
8th, I
provided.
think. 8th.
No, vacation court of time there. Will it be raised you?
So otherwise, 60 days offense, Lordship.
Yes, that he 46 days and 46
Lordship, let the
the
matter.
matter.
Lordship, can we come tomorrow? We'll take instruction.
Take instruction. Take come
Tomorrow.
tomorrow because he is the answer for 45, 46 days. That too, the specific instructions were there. That if it is statement was recorded, it has to be produced, or if it is not, or what is the forwarding no, or is also not available. If it is there. So that is the position. This tomorrow. You take the instruction.
Lordship.
Tomorrow, really.
Deep liberation.
So here,
Well, it's,
who is the other side? Oh, you are asking.
my lords, I'm grateful for getting accommodated today. Last time, my lords were very busy. So, much obliged, my lords.
Actually, what it is, I'm actually we are in division bank.
Yes. No, that I knew
So
that.
somehow some agreements that they are in division bank, so
Yes.
that's why we.
Today, I mean, I was hoping that by lunch, DB will be over. That's why my associate came first, but then he rang up that please rush. So, since I do live in a nearby guest house,
Ah.
it takes only 2 minutes.
Okay.
So, minutes, this is a case, just to refresh my lord's memory.
Ah.
This is a case where, under the Wildlife Protection Act, for violation of Section 29, I have been convicted
Hmm.
with RI of 1 year and fine of 10,000 rupees. But there are my grounds are threefold.
Hmm.
One is, of course, I have elaborated in the previous
Yes.
hearing.
Hmm.
That is whether the forest personals who have prosecuted this case were competent to do it because of the various this thing. The next point which I draw my lord's attention, my lords, I have given a bunch of paper book.
Yes, I have.
In that, my lords, this. In that, there is a item number 6, the Wildlife Protection Assam Amendment Act, 2009. It is page 69 to 71 minutes.
Hmm.
This is the state amendment to the Wildlife Protection Act 1972, which is a central act. So, state of Assam has, my lord, in the parent central act, the offences under the Wildlife Protection Act are non-cognizable. Since they are non-cognizable, the police or the SHO of the police station cannot take cognizance unless he is empowered by the learned magistrate under section 155 of the now repealed CRPC. But my lords, by this act, my lords can come to section 3 of this act, my lords. at the lower part of the page. In the Principal Act, after section 51A, the following new section 51B shall be inserted. So the state of Assam has inserted a new 51B, section 51B. Now 51B1 says, every offence punishable under this act shall be cognizable and none bailable within the meaning of the CRPC 1973. Well, this takes away the entire case of the prosecution case. A cognizable offence can be investigated only by a SHO of a police station or by the learned magistrate himself exercising his powers under section 203, delaying the process and then making further investigation either by itself or getting it done by the police station. So in this case, Millets, if at all there was an offence, by virtue of, and this is of the 2009, so I'm covered. So if at all there was an offence, which of course I'm contesting on merits also. So this was a cognizable offence. This should have been reported either to the police station or to the learned magistrate, who in turn would have either investigated himself or herself or had asked the police to investigate. What has happened in this case, Millets? The Forest Department of the state of Assam has acted as a police station, investigated a cognizable offence, submitted a report as if they are SHO of the police station, and thereafter trial has taken place. The learned special judge fell into serious error in not taking this into consideration, that Forest Department can only file a complaint under section 200 of the CRPC before the Ilaka magistrate, and they cannot file a police report under section 173 subsection 2 of the CRPC, or they cannot take cognizance of a cognizable offence and start investigation. So that is that, Millets, if that is taken into consideration by this honorable court, nothing survives. Because entire investigation is illegal, unlawful, bad in law, and against the provisions of the law. Therefore, my fundamental rights under Article 14 and 21 are affected. So that is my next ground on Millets. Then, Millets, I have already invited my Lord's attention that section 29 cannot operate independent of section 27. Because 27 is the unauthorized entry into the reserve forest. I am accused of cutting the trees. If I cannot cut the tree, Miller, without entering the forest. 27 has been dropped. The prosecution earlier in its complaint has pressed 27, 29, and 39. 27 is unauthorized entry in a reserve forest. 29 is destruction of the reserve forest, which will include unauthorized cutting also. And 39 is trading in protected species. So, Millets, the learned special judge, while framing the charge, dropped section 27, dropped section 39. But once section 27 is dropped, it means I never entered the forest, or I did not enter unauthorizedly. So, Millets, with due respect, if I did not enter the forest, I cannot cut the tree also. So section 29, section 39 can operate independent of section 27, because to trade in the protected species, one need not be inside the forest. Animal can be captured and taken to some other place. So to commit an offense under section 29, that is destruction of the reserve forest, unless I'm using some missile or something, Millets, I cannot destroy the forest or destruct the forest. So therefore, Millets, that is another legal ground that learned special judge fell into serious error in convicting me under section 29 when the court itself was satisfied that no case under section 27 is made out. That is the second measure. The third objection is, Your Honor, the complaint which is dated 27th of May 2017 is submitted to the Deputy Commissioner of Karbi Anglong. Well, a Deputy Commissioner is not a judicial authority. He doesn't have any judicial powers. District magistrates do have some judicial powers, but not to try a case now. Earlier, during the old CRPC, that is the CRPC of 1898, district magistrate has certain judicial powers or powers to hold trial. But in the CRPC 1973, district magistrate, though a category of magistrate, did not have. But deputy commissioner is not even a magistrate, my lord. He is purely an executive authority. Of course, deputy commissioner has forwarded this to the concerned magistrate. So what is my prejudice? My prejudice is, my lord, in a complaint which is submitted allegedly in the office of the deputy commissioner of Karbi Anglong, incidents of 29th May are mentioned. Let's, in a complaint created and submitted to authority on 27th of May, how did they know what would happen on 29th of May? My lord, my respectful submission is everything was backdated. That's why it was first submitted to deputy commissioner, because court would not have allowed them backdating and administrative authority may have. So it was first given to deputy commissioner. An entry was created as if it is submitted on 27th, and then deputy commissioner forwarded it to the learned magistrate for further necessary action. So on that ground also, Millet's whole thing becomes malicious and mollified and untenable in law. Now, Millet's, I will draw my lord's attention to the case on merits. Millet's, the case of the prosecution is that an information was received at 6:30 in the morning. No quarrel with that. Informations are received by public officers. But Millet's, while the prosecution take the shelter of the Repealed Evidence Act to say that they will not disclose their source because information given in confidence, they will have to prove which officer received the information. I'm not asking who was the informant who said that forest is being destructed. The prosecution never proved which particular officer of the forest department received the information. They did not even disclose. That is not protected. Public servant receiving information in confidence from a source is protected under Evidence Act, but the public officer is not protected. His identity has to be disclosed. The prosecution had to examine the public officer who received this information that certain people are destructing the reserve forest. Neither that officer is named, nor that officer was examined. So therefore, my lord, the case collapses at this stage itself, because the prosecution has not proved that any information was received. That is my next legal ground, Millet's. Now, if we believe the story of the prosecution that an information was received, it is allegedly processed by the beat officer. Beat officer is a junior Group C officer, Millet's. The prosecution did not show any document that the state government has authorized a beat officer to organize a raid. It has to be authorized by minimum a divisional forest officer as per the law. So, Millet's, this information must have relayed to some senior officer, who in turn must have taken the decision to organize a raiding party. That is not disclosed, not examined. That which senior officer decided. Because to intrude into the privacy of a person, the senior officer has to take the responsibility, make a recording on the file, say that I am satisfied based on the material or information brought before me, and it requires immediate action. Therefore, a search party should be constituted. That is the standard SOP in the government functioning, Millet's. That has not even been claimed. Then, Millet's, they have taken the police assistance. Nobody is telling to the Honorable Court that who spoke to whom. Police assistance can be provided, Millet's, only by the district superintendent of police or the SHO of the police station, because other authorities do not have spare police personnel. So in this case, somebody must have requested the district superintendent of police or the concerned SHO to provide some police assistance. That also is not disclosed and not proved. But police personnel have been examined who said that they were accompanying the forest officials. For what purpose, I will come to later, but right now I am on the police personnel, Millet's. Then, Millet's, there is a window of only 1 hour, according to prosecution itself. At 6:30, information is received, recorded in the complaint. At 7:30, I am arrested in the forest. So, Millet, in 1 hour, the information is received, verified, processed, recorded in some file or some register or something, relayed to the senior officers, who in turn authorize a raid. Then senior officers of the police are contacted. They provide the police assistance. The police personnel are picked up from wherever they are. They all march on foot, millets. No vehicle has been used. And they reach the precise spot, all in 1 hour. Millet, respectfully, it is not possible humanly. It's just not possible. The prosecution story has just been fabricated. Now, millets, if the police personnel were present, which admittedly were present, since it is a cognizable offense, it was the duty of those police personnel to report it back to the SHO concerned so that he could have acted under section 157 of the CRPC. Section 157 CRPC, repeal CRPC, millets, permit the police personnel to act as an informant, unlike section 154, where informant has to be a victim or somebody on his behalf having come to know about the crime. Section 157 permits the SHO or any other police officer if he gets to know. In fact, in the case of millet, Indira Gandhi, our Prime Minister, when she was assassinated, the complainant was the SHO of the Tughlaq Road police station. So nothing wrong. So these police personnel were very well within their authority to go to the concerned police station, take the arrested persons, and say that we have received an information or we have seen commission of certain crime. And that would have been recorded in the FIR register and FIR would have been registered. This was also not done, and not done on purpose because everything was being fabricated. Then, millets, coming to the facts of the case, millets, there is complete contradiction between the statement of the prosecution witnesses itself. The witnesses from the forest department and witnesses from the police department. I will draw my lord's attention to page 66 minutes of my appeal. Page 66 is the examination in chief of prosecution witness PW8, who is a constable of the Assam Police. On essay, I know the complainant, Sundar Singh Teron, beat forest officer, Lahori Jan, forest beat. The police officer has very correctly stated his status because he is trained in CRPC. He says, I know the complainant. He is not calling him the investigator. For him, he is a complainant. That is perfectly all right. Then, when the next line, the occurrence took place on 27/5/2017. At that time, I was posted at Lahori Jan border outpost as Assam police constable. On the day of occurrence in the morning, police personnel, forest staff, along with Assam police battalion, went for a patrolling at Nagaland-Assam border area minutes. The story of the prosecution is a raid organized by them, and the police personnel who is saying he's into the routine patrolling. Joint patrollings are routinely taken by the forest department personnel and police personnel. So, there is no raid. The prosecution witness, who is a relied upon witness, is completely negating that any raid has taken place. Then Millets, in his cross, on the next page, and in the last line on this page itself, Millets, there was no dwelling house at the place of occurrence. But at the prosecution forest department's story is that there was a temporary hutment which they were constructing. Now the relied upon witness, prosecution witness says no dwelling house, nothing. On the next page, Millets, page 68, first para. When we found the 5 accused persons at Doldoli Reserve Forest, we saw that the 5 accused persons were sitting there on the ground, there with dao, etc. There was no any temporary house at the place of occurrence. So 2 things, Millets, they were sitting on the ground and there was no temporary hutments. They were not cutting anything. They were sitting on the ground. That is the prosecution witness. Now, Millets, on the page 69, it's next page, the prosecution witness, this is 313 Millets. The learned special judge has examined, and last paramilla, bottom millets. Question PW1, that is the beat officer. Sri Sundor Singh Teron has deposed that on 27/5/2017, he was posted as in charge of Lahori Jan Forest Beat Officer. On that day in the morning around 7:30 a.m., he along with forest staff and staff of Lahori Jan border outpost went for patrolling alone. Now it is a recording of the court that they went for a patrolling. They didn't go for any raid, meaning there was no information. No raid was organized. That's why nothing has been proved. Neither the officer who received the information has been examined, nor the officer who authorized the raid has been examined. At Karbi Anglong border under pillar number 5 and 6, at that time they saw you and the other accused persons present that day in the court at pillar number 6 of Karbi Anglong, Doldoli Reserve Forest, which was 300 meters inside the forest, were cutting jungle and you were construction of the one temporary house with plastic. Now, the beat officer of the forest department has told the court that they were cutting the jungle and they were also constructing a temporary house. The police personnel, who is independent of the forest department, in his chief has said nobody was cutting anything and there was no hutment and nobody was constructing any hutment. So, the forest department witness is the complainant. He is an interested party. Though police officers are also not independent witness because they are state officials, but still they are not under the control of the forest department, so they have spoken the truth, what they saw. Apart from the fact that no search was authorized, no information was received, nothing was done, everything has been cooked up subsequently. The police personnel who has been examined and are relied upon witnesses have completely contradicted the prosecution story that jungle was being cut and a temporary hutment was being constructed with plastic, etc. So, next question which the court has asked, Sri Sundor Singh Teron has further deposed that when they saw you and the other accused persons, they went nearer to you, and as you and the other accused persons were from Naga community, they asked you and the other persons whether you had any permit or license to enter 300 meters inside the Dondoli Reserve Forest of Assam Nagaland border. You were not able to show them any proof to enter into the reserve forest of Assam. My lord, I have not entered the reserve forest. That is the case of the court itself, because 27 has been dropped. So, my lords, I have answered that is not true. So, my lord, these are laborers. They cannot be given the elaborate legally paraphrase answer. They simply said it is not correct that we have entered the forest. Similarly, my lords, the next question of the court is, Sri Sundor Singh Teron has again deposed that then they searched you and the other accused persons in your belongings and saw one deer's leg about to dry, one wild buffalo's horn, 3 numbers of dao, 8 mobile phone, etc. Well, at the forest department are trained. They know deer, all kinds of deer are protected animals. They cannot be killed unless there is some authority of the state. So the case was that one deer's leg about to dry, that means it was recently amputated or cut, was found. And this has been rejected by the court itself. Section 39 has been dropped, though pressed by them. They did not send the deer leg or the wild buffalo horn for FSL test. Only forensic laboratory would have determined whether it is deer's meat, deer's leg, or buffalo horn or not. They didn't do it deliberately because they knew it was not deer's leg. Nothing was found. So that also is contradicts. Then on the page 71, Sri Sundor Singh Teron has again deposed that he interrogated you and other accused persons, and Forest Guard Milanson Engti recorded your statement. Now, this is the patent illegality, violation of all law, including my fundamental rights under 14 and 21. Where is the power given to the forest officials, a forest beat officer, to interrogate an accused? Power of arrest is there. They can apprehend, produce him before the London magistrate. Magistrate will decide whether to keep him in custody or release him or whatever. Where is the power in Wildlife Protection Act? I have not been able to find. Maybe my learned brother can assist the court. to interrogate a suspect. Power of interrogation is specifically given under the all special acts like Income Tax Act, Customs Act, GST Act, earlier Central Excise Act, PMLA, etc., etc. So, Millets, under the Environment Protection Act, offences are made punishable. Cognizance is to be taken in certain manner. So, only SHO of a police station or a police officer authorized by learned magistrate under section 202 and 203 can make interrogation, can interrogate a suspect. Here, the beat officer is acting as everything. He is a police officer, he is a forest officer, he is the court. So that itself betrays the patent illegality committed by the state of Assam through its forest department officers. And my answer is very clear. I'm a laborer, Millard. I'm not even capable of speaking English correctly. I can only speak vernacular. My statement was recorded forcibly. So I have very consistent in 313 by the learned special judge that my statement was recorded forcibly. Then, Millets, the court has asked in the next questions about these deer's leg, etc., showing photographs. But since 39 was dropped and they never sent those pieces to the FSL, so those things, Millets. Now, Millets, page 73, question number 9 minutes of the court. Shri Rishad Hussain, he is a forest official, Millets, has deposed that on 27th May, he was posted as forest guard at Lahorijan. On that day, he, along with the forest staff, went for patrolling at Assam-Nagaland border. At that time, they saw you and the other accused persons present that day in the court were cutting jungle at pillar number so-and-so, so-and-so. Now, Millets, even the forest guard, who is a forest department official, a junior or subordinate of the complainant beat officer, is not talking of raid. The complaint talks of a raid. Information is received, a raiding party is organized, raid is conducted. He is also saying we were patrolling. Now, patrolling is not raid, Millets. From any stretch of imagination, patrolling is just routine patrolling. You just keep observing the area. So that also contradicts. Now, Millets can come to page 74 and 75. The question number 13 that starts from page 13. Sri Surya Rongpi has deposed that he knows the complainant, he knows you and the other accused persons. The occurrence took place on 27th May. At the time of occurrence, he was posted as forest guard, so again forest department official. On the day of occurrence, they came to know from the secret source that some persons illegally entered the Doldoli Reserve Forest and were cutting the trees. After getting the information in the morning at about 7 a.m., they, Forester 1, along with one section of forest staff and Sri Lonki killing of Lahorijan Border Forest Sub-Beat, office and battalion personnel came out to the place of occurrence under the in charge of Sri Lonki killing. But now the forest department itself is contradicting its story. Earlier they were patrolling. Now they are talking of raid. So their junior officers probably they were not properly, counsel to say. So they said what they had remembered, and that's why this contradiction was. Then Miller, next question is question 14 is again the court is asking that you are cutting the jungles. Well, question number 20 on page number 78 minutes. 313 statement minutes. Page 78 minutes. Question number 20. It is the fifth line from the top, next sentence. On the day of the occurrence in the morning at about 6:30 a.m., they, along with the forest staff, Assam police, and one section of battalion party went for patrolling from the Lahorijan beat office to Doldoli Forest Reserve and went towards so-and-so. Again, and this is the statement of Kharsing Rongpi, who is also a forest guard. he is also saying patrolling. So, my lords, the prosecution is not clear whether it was a routine patrolling or it was a special raid. Raids are not routine, my lord. They are organized especially. So, beat constable is a beat officer is saying that it was a raid. Forest guards are saying it is patrolling. Police officers are saying it is patrolling. The court is also treating it as to be patrolling. Now, minutes. Page 83. I'm sorry. Page 83 minutes. The last but one question the court has asked. Do you have anything to say in your defense? These are laborers, millets, manual laborers. Forest staff apprehended us from our place, which is situated in Nagaland side. Then we were forcibly taken into the Assam side. Then we were sent to DFU protection lockup room. Other than mobile, PAN card and small handbags, nothing was found from my possession. I am innocent and have been falsely implicated in this case. This is my 313 statement. This has not been rebutted by the prosecution in the final arguments. So, millets, what actually has happened, I will draw my lord's attention to page 174 minutes. Millet, I am a bona fide patta holder. Page 174 minutes and except 22. I am a bona fide patta holder, millets. I have been given land by the village council. This is on the border. I was working in my land when I was accosted by the forest guards and pulled over to the Assam side of the border. So it's slightly, I mean, this thing, but my associate says that it has been obtained from the village council. And T. Ezan Lotha is father of one of the convicts. So they were working in their land. This has also not been rebutted by the prosecution that land does not belong to them or land is not nearby the border. So they were either working in their land or they were sitting in their land when this routine patrolling ran into them or accosted them and brought them. So, my lord, with due respect, millets, neither the forest department has the power to investigate, nor any case was registered because an incident having taken place on 29th of May 2017 could not have been reported on 27th May 2017. That itself takes it away. It is a cognizable offense, so only a police officer could have investigated and registered the complaint, or a London magistrate could have authorized investigation. The complaint is given to the deputy commissioner, who is nobody. Forest department does not work under the deputy commissioner, so why it was given, that makes everything suspect. Deputy commissioner then forwards, he should have immediately told them to go and file it with the court, the competent court. Then, millets, section 27 is not pressed against me. So 29 cannot happen without 27. 39 can happen, but 29 cannot happen. And then, millets, there is contradiction between the witnesses itself, apart from the material fact that no independent witness was examined. So once there is no independent witness, millets, criminal law is very clear. There is no primary evidence, only secondary evidence, that is substantial evidence, circumstantial evidence. And circumstantial evidence, millets, the prosecution witness themselves are contradicting. It has been established, the court itself has accepted that section 39 was wrongly pressed. No deer leg was found, no buffalo horn was found. They have cooked up this story. So, my millets, in 313, all witnesses, this is the similar answer given by all 5 accused. Millets, all 5 convicts have been consistent. They were not that well versed or articulate in language, so they could not probably say what a lawyer can say. But, millets, they have been very consistently saying that we are innocent. We were in the Nagaland side. We were forcibly brought by the forest people. And all circumstances are very clearly indicating, millets, that everything has been fabricated by the forest personnel for whatever reasons that I don't want to speculate because that is not required. But the case of the prosecution is not maintainable, millets. My respectful submission is that innocent persons have been convicted. So my lord should give me justice, hold me to be innocent, and restore my honor and prestige. That's all.
My lord, as my senior colleague has, my lord, brought some factual as well as my lord some legal points. So I need some time, my lord, for my reply. And if lordship allows me, I will file a written argument on behalf of Forest Department. So immediately, maybe
Now,
fix and
this
immediately
matter
after.
was in fact part third was there.
My
So
lord.
because the
So, my lord, his part is complete, my lord. Only
But I don't know what will be his argument. I'm entitled to a rebuttal if he counters my arguments.
yes.
So oral, I mean, maybe 5 minutes, but because obviously my brother will say that what I'm saying is not correct, not maintainable. So in that case, I will have to assist the court. It's a criminal case. So submitting written synopsis, of course, will help the court. But before that, we should,
Sharma, you are going to fight today, not today.
Not today, my lord.
You need
It's not
some
possible
time.
for me.
no, time limits. Okay, I will adjust. I mean, he can adjust me, but I will need at least 5 minutes of court's time after my brother has submitted his written arguments,
Okay. That's
so that I can just assist the court, point out the inconsistencies.
that's okay. Yeah,
So whatever it is, so 1 day, 8 minutes, subject to my lord's convenience. So
okay. No, one day it is that he's going to submit the different, maybe there may be some oral submission also.
Oh, yes, my lord.
So,
what I will do is, once I get the copy, I will go
I
through it.
will furnish copy.
If oral submissions are
No.
required, I will make a request on that day.
okay.
If not, I will myself make my synopsis self-contained, including covering his arguments. And if that will be enough, we can submit both, and my lords can reserve the order. Alternatively, I will request for 5 minutes of court's time.
Well,
As per your lordship convenience after vacation, my lord.
first if you want that big date there or
My lord can fix the date because otherwise my juniors are taking dates. So if they don't find,
20,
any other cases you have it?
I have cases, my lords, I have in CBI court. I also have some matter in Kohima bench. So, my lords, I mean, I'm subject to my lords, I mean, court's convenience. After 20th, my lord, any date.
20th of this month.
Maybe November also.
November, it may not be possible. I'll be at Kolkata.
Okay, my lords.
So
No, 21st I'm not available. I'm in Patna High Court. 25th also I'm in Patna High Court. So we can take 28th, 29th, 30th. If
well, it can be possible after vacation, obviously, but
no, not possible.
then it's so fine.
My lord, maybe after my lord's that 2 days that my lords is not sitting here.
My lord, in the month of October, my lord, after vacation.
21st.
My lord, in Arunachal, maybe.
Tuesday 9 is Tuesday, that is the hearing day, that can be fixed.
Yes, my lord. Yes.
29
9th
minutes.
of October. Only you.
No.
No.
Cases.
Okay.
Parted cases.
Okay.
Well, at 29th, I have parted cases. In there. Maybe 30th, I can make it if it is possible.
30.
30. Subject to my lord's convenience.
Is it Thursday or
30, it is Wednesday, my lord.
Even 31st is okay with me, subject to
31st is holiday.
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 Oh, Kali Puja.
Oh,
Diwali.
Yes.
Delhi, my lord, 31st is not holiday.
In
Delhi Kali Puja is not a holiday. Kali